Hello everyone, we welcome you to the first session on contracts for your next coming exam. This is also a free and introductory session for contracts. So we have prepared four different types of material. I'm going to show it to you, and then your instructor, Hannah Moll, who is my colleague, barrister and solicitor in Ontario, she is gonna explain to you what is included in this material. Yes, please, Anna. So what is this material is your...
So there are a couple of things that you would be getting from us. First is slides. This is a typical PowerPoint presentation that we usually offer. They are about 185 slides that you will receive. The purpose of these slides is to break down the concept for you in the simplest possible fashion. See, contracts is a challenging subject, right? We all know that. It is one of the subjects that has the highest failure rate. However, if we focus on getting our concept right, if we focus on applying the law correctly, and if we focus on these IRACs, which is something, this next thing that you will get from us, you would be able to put everything together during the exam. Now, the second thing that you're going to get from me are these IRACs. These IRACs actually run into 85 pages. The idea behind these IRACs was to help you identify issues. Most of the candidates in contracts are not able to identify the legal issue involved. So when you see rules, analysis, conclusion, and it goes for every case, existing case that we have, the reason I have done this is so that in a given fact pattern, you are able to identify the issue involved. If Amar, can you please scroll down? This also serves as your quote unquote brief notes that you can carry to the exams. If Amar, can you please continue to scroll down?
Mhm.
If you see, this is pretty much done for every every chapter, every topic that you have to touch in your syllabus. Please note, I have prepared this for every topic. So if Amar will scroll down, he will show what all materials, how we have prepared these. So for every case I've discussed this. Was there a contract? What rules and analysis, what rules are you going to apply? How will the conclusion look like? So this is the second material that you're going to get.
Now
The
the third material.
the third material that you're going to get are questions that I have prepared for you. These questions, if Amar will scroll down, you would realize they are dependent on various topics. These are certain fact pattern questions that you have, multiple choice questions that you have that basically test your concept. We will be discussing some of these questions, and some of these questions are practice questions that you are required to write. You can send in your answers to me, and I give individual feedbacks on each of these questions. So this is the third material that you're going to get from us. So, and you're going to get access to the previous recordings that you have. So in a sense, we are looking at four things over here: past recordings, slides, and brief notes, all your case summaries, all the IRACs that you might require, and finally, questions that you need to practice. And, you will also, uh, um, the ones that I will also discuss, some of them in the class. Besides that, I will also give you 2 sample answers that will help you identify how to go about writing a model answer. 2 or 3 sample answers I will share with you. These sample answers have not been uploaded on the website yet. I'm going to talk about them and show them to you when we have our exam session. So this is what you will be receiving from us. And of course, I will be diving deep into each of the concepts that are covered or that you are required to cover in your syllabus. So this is how we are pretty much, structured the whole course for you so that you are not stuck anywhere. You know how to deal with IRACs, how to deal with issues, so on and so forth. So this is what you will be receiving from us. And today's session will specifically focus on understanding your syllabus and trying to finish one topic that I know candidates find difficult. So those of you who won't be signing up with us will also have that basic understanding of that topic. So this is
Okay, I'm going to show you all the participants. So Hannah has already explained that you will get 4 different types of material. Now I'm going to show you that those of you who have already purchased and are regular student, so they have already got access to these recordings. Please sign into your account and then you will see lesson 1, lesson 2, offer and acceptance, lesson 3 that covers topic 3 and 4, lesson 4 that cover topic 6 and 7. We go by the NCA syllabus, lesson 5, topic 8, lessons, and then there are 7 lessons which are detailed video recordings on the as per latest syllabus. Some of the members have asked me, is it as per latest syllabus? Yes, please. Also, just to give you additional resources, we also give you the previous recordings. So they are the recordings from the May session. So you get minimum 15, 16, 17 hours of recordings from this green. And then this is a complete cycle of another recordings. So the basic concepts, they remain the same. However, the participants are different in the May session as well as in September session. Sometimes the members would ask the question, then you also get some extra additional help. These are, my dear friends, the recordings content. I'm also going to show you, if you click on materials and practice question, you will see all that material which Hannah was talking about. You have the option to click on view full screen, and then this material will be available to you. This is material number 1. You can also call them in a simple language. They are kind of brief notes. Then this is the material number 2. These are sample questions, hypothetically created fact pattern questions just to help you understanding the concepts. Then these are 2 additional materials which have lately been prepared. They are kind of IRAC material because many participants, they like to understand better. They understand better that if there is an issue and if there is a rule and analysis conclusion, this material lately we have updated and this is part of your package. So any member who is interested in joining, please contact me after 3 hours because I will be busy in my criminal law session. If you are interested, you are welcome to join. Some of the members, they might like to purchase only material. We have not discussed that in detail, but we will see if we want to offer that option now. Huh? Okay, Hannah, so you can continue with the session. I will be leaving and then uh, you can share the recording
Yeah,
on.
I just wanted to be very sure about uh, what
You can stop sharing the option.
that's exactly what I'm doing.
Right, right.
All right, so I think we are going to start the session. What I would request all of you to do right now is to get a copy of your contracts syllabus that NCA has. It is something that we will keep with us every single time we take the class. Okay, so keep a copy of your NCA syllabus of contracts. Okay, and with that, let me start sharing. Is my screen visible to everyone? Is my screen visible to everyone?
Yes.
Okay. So first of all, we are going to be studying from the syllabus, which is revised as per April 2023. Okay. So this syllabus that you have is the latest syllabus that we will be using. Okay. In the event there are any changes that are made to the syllabus, any amendments, any additions, any deletions, I will update you and we will study as per the latest syllabus then. For now, we are going to be studying and using the syllabus that is as per April 2023. Just give me a moment. Somebody by the name of 538245 has joined the session. Can you please unmute yourself and let me know? Okay, so the person has exited the session. All right. So let's start looking at what is it that you need to focus on as far as contracts is concerned. See, the NCA says that it is a foundational course that requires understanding of issues surrounding contract formation, breach, performance. That means you have to have an understanding of basic issues that are involved in contract. I understand that sometimes candidates find it challenging to identify the issues that are involved in a contract. It is here that in order to sort of meet this need and meet this requirement, I have prepared IRACs for you. These IRACs are basically existing case laws with identified facts, which will tell you how to pick up those issues. Okay. So when we talk about understanding of issues, we need to know, we need to be able to identify where is the problem here and at what stage did the problem occur. Did the problem occur at the time of formation of contract? Did this problem occur at the time of performance of the contract? So we need to be able to identify issues. So that is one. Second, please note, whenever we are talking about contracts, we are essentially looking at either a real estate contract or a labor and employment contract or a commercial law contract. So other legal disciplines are involved. What is the subject matter of the contract? And therefore, understanding of issues against the backdrop of that subject matter is extremely crucial. The syllabus is designed to give candidates sufficient exposure to law of contract to grasp it and apply it competently in the practice of law. Finally, what is the area? How are you going to be tested? See, most of us think that, oh, NCA is out there to fail us. No, NCA doesn't want to do that. It's not your personal enemy. You need to read the syllabus in order to understand what is the purpose of the exam. What is it that they're testing? So the function of contract exam is to determine whether candidates have acquired a proficiency. Have you been able to gain proficiency in the main doctrines of contract law? Are you able to spot frustration of contract? Are you able to spot misrepresentation? Are you able to spot, let's say, that, the consideration was not given in this contract? Are you able to spot capacity issues? Are you able to look at termination of contract? Were you able to spot breach of contract? So these are various doctrines and principles of contract law that you should be able to identify in a given fact pattern. Also, on some occasions, we find that they combine these issues. The problem is not just with frustration of contract. The problem is also with formation of contract. And this is where we are going to focus on every single concept as we go. Okay? The proficiency does not only require you to know the rules, but also to be able to apply the rules on a given fact pattern. It is here that I tell all the candidates that a very good exercise is for you to go and download the NCA sample exam paper. NCA's website has NCA's sample questions, sample exam papers. Start answering them. It is a very, very good exercise to do so because it will give you an insight into what the NCA expects from you, how the NCA questions are drafted. How is it that you are going to be able to address the issues that are in the syllabus? Okay. Therefore, a very good starting point is to be able or is to start answering those questions. And I would urge all of you to do that. I will be showing you a couple of sample questions and answers as far as that particular. Okay. I will have to stop the recording because somebody has just entered the class. Give me a moment. Okay. So let's go back and start looking at your syllabus once again. So I was talking about how it is crucial that you look at the NCA sample questions. That's a very, very good point. That's a very good place to start answering questions. I will show you a couple of answers to those sample questions as well. Those answers have been prepared by my previous students, and therefore I will not be able to give those answers to you because the copyright on those answers exists with them. Then, like I said, the syllabus requires that you should be able to identify issues, use assigned cases and materials, and also have the ability to explain why the outcome that you have arrived at. If you think there is a problem with the formation of the contract, don't just state that there's an issue with the contract. Explain why and how you have arrived at that conclusion. See, when they say that you should be able to identify, they are not just asking you to stop at identification. They're asking you to go a step further and say, please explain how have you arrived at that conclusion. That means you are not just, and it says so, that they're required to do more than just spot issues and regurgitate rules. You should be able to solve legal problems. You should be able to tell them where is the remedy in this situation. Please note, this is for all the students who might not sign up with us, that you are required to provide remedies in every single situation. Any answer in contract that does not contain remedies, that does not begin with whether the contract is valid in the first place or not, that is an incomplete answer. Your answer should be structured in a way that your opening sentence should clarify whether the contract is valid in the first place or not. Because if it is not a valid contract, whatever analysis that you are undertaking is incorrect. It will fall flat. So your starting point always has to be, is this a valid contract? If once you have identified that this is a valid contract, then you start analyzing the problems and you close your answer by suggesting remedies. Any answer that does not address the issue of remedies, how are you remedying a situation? Because clearly NCA is saying you should be able to solve a legal problem. How are you remedying a situation? if you do not tell them how are you going to remedy the problem, if you do not tell them that you were able to identify that this is a valid contract or not, so long as you're not able to do these two tasks, the analysis that you've undertaken is incomplete and on some occasions even incorrect. So how are you going to start your journey? Who's going to answer that? Let's see. What should be the first issue that you should address in your answers?
Whether it's a valid law or not. I mean,
Whether
valid
it is a
contract.
valid contract or not. And how should you close your answer?
With a remedy.
Correct. You will let your examiner know that not only do I understand the problem, I'm also giving the remedy that needs to be given in this particular situation. And then you will explain why did you choose this remedy. And that's how you're going to close your answer. Anything else will not fetch you marks. So start from the beginning and end at closing it with remedies. You should be able to do that. Okay? Any questions, anybody? Any questions? Any issues? Any questions, any issues so far?
So
Oh.
Hina, I have one question.
Yeah.
So in the before other NCA exams, so the sir suggests that do not copy the IRAC format. So is it in the same rule apply in the contract?
Yes. Yes. Please don't. Please don't copy. Because if you copy, okay, so what happens is it amounts to plagiarism. And if you see, NCA categorically states that if your answers are plagiarized, you will not, they will not fetch you any marks. So yes, you're required to write in your own language. The IRACs that I will share with you, which are uploaded on the website, are only to give you a direction as to how do you have to use them.
So for example, Hina, if I identify that this contract is valid or not, for example, in the issue, so I have to first look the what the question is asking about, and those one is my first issue, or I can just start the answer with the in without the IRAC form.
Okay, so this is a very good question, Sanjay. The thing is that when you are starting your issues, in your issues, you will say, has the plaintiff, or for instance, has the defendant or has Mr. So-and-so breached the contract? Has Mr. So-and-so given consideration for contract? Or is this a valid consideration? These issues are going to appear. Then you're going to mention the names of the case laws that are you going to use in your analysis. And finally, when you start analyzing, your opening sentence will say the contract in question is a valid contract because it meets the requirements of a valid contract. The first issue that requires to be analyzed in the given set of facts and circumstances is state the issue, start analyzing. This has to be your opening sentence. But let's say if there is an issue with the formation of the contract, then your first issue is going to be, is it a valid contract? Or does it meet the requirements of offer acceptance consideration? Then you're going to analyze using that statement. But let's say there is no issue that you find with the formation of the contract. You find that this is a valid contract. The issue in this case is about, let's say, misrepresentation, or the issue in this case is about, let's say, illegality. Then you can simply say, while all the requirements in the, of a valid contract are present in the given set of facts and circumstances, we find that the purpose for which the contract was entered into is an illegal purpose, and therefore the contract in question is void. The question now arises, or the first issue is the purpose illegal? And then you will say, in Canada, sale of arms is considered an illegal activity, and since the purpose of the contract was sale and purchase of firearms, as per the case law, mention the case law, give your, just state the case law. You don't have to talk about the entire facts of the case that you're using. Mention the ratio and move on. So once you do this, once you have that flow, it's a perfect answer. But if you find an issue with the formation, then it will appear as a separate issue. In the event there is no issue with the formation of the contract, then in your analysis, you can simply say, this is a valid contract, which means you have told the examiner that you are starting from the premise that this is a valid contract. Okay, Sanjay? Does that answer your question?
Yeah. So Hina, if for example, in the hypothetical situation, if I will get the three parties in the one questions, mean for example, I have the contract between three persons in the one questions. So then I have to then they, for example, ask what is your duty towards each of the person.
Yeah.
So how can I answer these type of the questions?
So then in that case, you will have to see what are these parties? What are the roles that these parties are performing? For instance, is this party constructing something? Then you need to know, how are you related to the party? Are you paying this party? Did you enter into a contract with this party? Is this party advancing consideration on behalf of someone else? So you have to analyze, when you say your duties with regard to each of these parties, first see who are you? Who are you? And then what is your relation with each of these parties? Were you the offerer? Were you the person accepting the offer? Were you the person advancing the consideration? Were you the person performing the contract? Were you the one who breached the contract? Were you the one who misrepresented the contract, the terms of the contract? Who are you, Sanjay, in the first place? And then what is your duty towards each of these parties? Let's say you're the offerer in the contract. Then as an offerer, what is your duty? You have to mention the terms and conditions of the contract clearly. Otherwise, it will amount to misrepresentation. You will have to tell them what is the consideration that you're looking for, because a contract that is without consideration is invalid. Then you will have to look at what is the purpose. Perhaps you're asking somebody to, I'm offering to pay $50,000 if someone shoots X person. Then it is your job to remember that the contract that you're offering is and should be for a legal purpose. So you should be able to identify these depending upon who you are in the contract. And in case it's not you, let's say it's Mr. X and Mr. Y and Mr. A, then you should be able to know what are the duties that Mr. X has towards Mr. Y and Mr. A. Is that all right, Sanjay? Does that answer your question?
So Hina, I don't need to break down with each person my duties.
You should, depending upon what role they are performing. That is what I'm saying. Let's say you enter into a contract with Muhammad where you will pay $100 to Muhammad, and Muhammad in return will construct something for you. Muhammad, in order to undertake that construction, has gone to Nikhil to purchase cement. Muhammad has not paid cement. What is your duty towards Nikhil? Nothing, because you don't have a contract with Nikhil. Muhammad has a contract with Nikhil. So technically, you have no duties towards Nikhil. But what are your duties towards Muhammad? The fact that you will pay on time. The fact that you have identified the exact nature of work that needs to be done. So you will eventually break your role. You will eventually mention your duties as far as Muhammad is concerned and as far as Nikhil is concerned. You have known your duties towards Nikhil, but you definitely have duties towards Muhammad. Now is it clear?
Yeah, thank you.
Anyone else? Any questions? That was a very good question, by the way, Sanjay.
Thank
How
you.
do you address when you have multiple parties? You should be able to very clearly identify who is doing what in the contract. Think of contract as a film. Which actor is playing which part? Who is doing what? That is how you arrive at a contract answer. Any questions, anybody? Fozia, Sonia, Nikhil, Kushwant, Suvasti, Essie, Aarti, Adiola, Raman, Oluwatsun, Cynthia, Rashmi, Shubham, Sam, Mohammed. Any questions? Have I missed out anyone's name? Any questions, anybody?
No, thank you.
No, ma'am, you continue.
Okay. So you should be able to identify who is doing what in the contract. If you have that clarity, the exam becomes super simple. Once again, what is the examination includes? It includes problem-based questions, which requires candidates to analyze fact patterns. That's why I'm saying, who is doing what in a fact pattern? In a fact scenario, right? What are the duties that the parties have towards each other? This clarity has to come. This clarity is very, very important. You should be able to apply relevant law to the facts. You should reason out the conclusion. Do not just state what the conclusion is, provide reasons for it. Why have you arrived at that conclusion? Why have I arrived at that conclusion? What is the conclusion resulting in? Okay. The examination may also contain multiple choice questions and or short answer questions. I have 75 multiple questions that I've prepared for you. They have already been uploaded on the website. Please practice them. We can discuss some of them in the class if you are not able to arrive at the accurate answer. Okay. The examination may also contain multiple choice questions and or short answer questions that require candidates to demonstrate their facility. How much at ease are the candidates with the contractual principles when it requires evaluating a law? And you should be able to discriminate between sound arguments and unsound arguments. Once you are able to do this, you have essentially demonstrated your expertise, entry-level competence as far as the paper on contracts is concerned. And this is what we need to focus on every single time. The case book that you're required to read is Ben&Shai. The notes that I've prepared for you, the slides and the brief notes, they all are from Ben&Shai's book. So essentially, I've read the book, culled out and scooped out materials that were relevant to you, and are those, I've like sort of used them to prepare your slides and everything else. Okay, these are other textbooks and assigned readings, which I have not really read because examination is typically based on your compulsory casebook. Okay, this is how your syllabus is. We start with indigenous peoples and contracts, and we are going to look at this particular topic today. Tomorrow, we are going to start with offer and acceptance, certainty of terms, enforcement of promises, privity issues, interpretation, exclusion clauses, frustration, and other things. As we progress, we are going to look at every topic here and cover, and as we go topic by topic. But first thing we're going to start off with is indigenous peoples and contracts. Any issues, anybody? Any issues? Fawzia, Mohammed, Sanjay, Sonia, Nikhil, Kushwant, Suwasti,
No.
Esti, Aarti,
Uh,
Ajbola, Raman, Rashmi, Cynthia, Olu Watson, Shubham, Sam. Any questions?
Hina, can I ask you one question?
Yeah.
So Hina, is, for example, if we would get a question on the basis of the case law,
Hmm.
so do we know, for example, in the other subjects we mention the case law in our syllabus, but in this contract there is no case law mentioned. So then how can we identify which case law is important and which case law is they are being going to be asked? Because sometimes they ask a random case law and the question is based on the case law.
I have dealt with all the case laws that you need to focus on, Sanjay. And also I have, if you read the IRACs that I've prepared, it's 85 pages.
Okay.
It's 85 pages of case law. So yeah. And then of course, if you want, you can have a look at your book and see if I've covered all the case laws or not. And if there are any specific case laws that you want me to cover, I'm happy to cover them for you. Okay.
Okay, but Hina, you have already have experience and you know which one is a more maybe important, because 85 is too many case law. I think it's so much hard to remember the 85 case law.
You don't have to remember them. How will you remember them? Like those materials, you'll be able to print out those materials and use them in the exam.
Because sometime Hina they ask me so much in details about the case law.
So let's see what we would be focusing on. Like I said, these are the kind of IRACs that you will get. For instance, if I say I'm willing to sell this pen for $5, am I making an offer? The answer is no. You're simply quoting the price. Here, like for instance, the first case, Harvey versus Facey. These are the facts. This is the issue, rules and analysis, and finally the conclusion. Similarly, I've done this for every single topic and for every single case law, as you would see. All of them. You would know what are the facts, what is the crux involved. Was there a contract? Did a valid contract exist between the drivers and the lot owner? Once you are able to establish, how do you deal with further steps? What do you do which is specific to bids? And if you've seen, I have identified these issues for you. The purpose of doing that is so that you are able to confidently identify issues, use rules, analyze the fact pattern. I've done the analysis for you. Yes, what I know, these are like 85 pages, but then the thing is, if I don't give IRACs, then the issue is, what do we do about the IRACs? These are the IRACs. For every topic, every case law, I've prepared the IRACs for you. Literally, there's nothing that I've not touched in them. How has the duty evolved over a period of time? Duty of good faith. I've not just mentioned the case laws. I have gone in great depth to discuss all of them with you. What was the issue? In each of them, I have identified the issues for you. The purpose of doing that is that you have a ready-made document that you can go to. Okay? Is everybody clear with that? The purpose why this has been designed this way? Why have I done this? How will it help you? See, you have the option of not using it. It's updated, it's uploaded on the website. If you think too bulky, I don't need it, don't take a printout, it's fine. But those who are interested in reading them, who are interested in carrying them, who want that in the event some question comes and they should be able to answer, for them, this is a valuable document. Also, in the exam, if you feel that, okay, I am unable to spot from which topic the answer has come, you can go directly to the slide, which I will be using to teach. Any questions, anybody? Sonia, Sam, Shubham, Olu Watson, Cynthia.
No, not so
No, ma'am.
far.
Ma'am, I
Thanks.
just have a question here. Like you just touched upon that there will be MCQs also into the question. It may come up. So like in these MCQs, do we need to give the explanation also, or we just need to come up with the right conclusion? I mean, that is the right answer.
Pick the right answer, that's all.
Okay, good. Okay, thanks.
MCQs are multiple choice questions. Just identify. If you go to the website, there are 75 MCQs that I have uploaded. That is for your practice. Please do them and share the answers with me. Is that okay, Nikhil?
Yes, yes.
Mohammed, any questions? You're awfully quiet.
Me?
Yes, any
Oh,
questions?
no, I'm just observing.
You
Yeah.
wanted IRACs, so I've made IRACs for every topic in every case law, Mohammed.
Yes. Yeah, I saw it. Thank you. Really appreciate it. And I would really, if you permit me, like, I want to advise students about something which it's really, like benefiting all the students.
Yeah.
I did not did it for the contract in the previous exam, and unfortunately I failed. I would say, guys, you have to practice. Practice make you perfect. You have
But
to practice, like
for
either the exams and the NCA, like in the NCA website itself, or like you could find the questions from I think UBC University in British Columbia. In their website, they have like a lot of question in contract law. You can obtain it, and then like you try, like you practice and you answer it yourself, and then Hina, she can review it for you. That's will really make you perfect.
Thank you so much, Mohammed. You did that for TOTS. How was your experience?
Yeah, it was 100% easy exam for me. When I followed your instructions and your advice that I have to practice.
Yes. Unfortunately, if I had this magic wand where I could just tell you, okay, study little and it's all going to be okay, I would do that. These exams are difficult, they're challenging. And the reason I'm giving you the study material is so that you're able to maximize your experience as far as, or optimize your, optimize your prep. Okay? With this, I will start the first topic on the syllabus, which is
Anna,
Yes,
I have one question. Sorry.
Fauziya. No, please. continue.
Are we getting this material of cases which you prepared? Because I cannot see on the website. And if it's in Messenger group, I don't know about that, but like, can
Okay,
you?
so the materials are with Amar. I
Okay.
think he will upload it today because the materials reached him yesterday. I
Mhm.
sent everything to him yesterday. Give him a day. I think
Mhm.
he'll upload everything in a day or two. And after
Okay.
you're still not able to spot these materials, the person to connect with is Amar because
Okay.
he has all these materials with him.
I
in his
think
team.
Hannah, the materials is in the website, but I'm not sure if if we can download it.
No, they are not downloadable. You'll have to print them. And these materials, once you print them, you can carry them in the exam. And you can take a printout on both the sides so that it doesn't become very heavy for you, Mohammed. And they would be uploaded, I think, either tonight or tomorrow. Amar is the right person. anything to do with the website, candidates, please speak with Amar. All the materials, everything is with him already.
Okay, sure. Thank you so much. Actually, I couldn't see there, so that's why
I can imagine must have been slightly disconcerting because I was talking about everything is on the
Yeah.
website. I was under the impression they have been uploaded already. But in the event you cannot spot them, he's the right person to go to.
Okay, sure. Thank you.
Ma'am, I also have another question. Like, I am new to Amar's group. I mean, like, this is my first session only. Previously, I am using Vanessa's notes, and I do have contracts notes for Vanessa, which I recently procured. So, would you suggest that shall I go with that notes, or do I need to
Entirely
purchase
your
the?
call. It's entirely your call. It's up to you.
Mhm.
But I know that Manual offers discounts to our students.
Yeah.
So there are hefty student discounts. So if you want, it depends on what you want. If you want
Right.
good and inexpensive, you can go to Manual as well.
Okay, sure. Thank you so much.
So the first topic that we are going to do today is indigenous peoples and contracts. Okay. So do you know who are indigenous peoples? Yes, Essie?
How long is this class, please?
It's going to be for some time. Why? Another 40 minutes. Why?
Okay, I'm just asking because I need to step out. Thank you.
Okay. So indigenous people were native Canadians. Okay. So when Britishers first came, or when foreigners came and started establishing contact with them, they realized that indigenous people have their own societies, have their own laws, and have their own ways and means of doing business. Okay, so when we are talking about entering into a contractual relationship with indigenous peoples, these contracts are different from the way contracts operate in common law. In common law, we look at offer, acceptance, consideration, privity, legality, so on and so forth. But when we talk about contracts with indigenous peoples, the first thing that we need to keep in mind is that they are different from the kind of contracts that we are used to, we are accustomed to under the common law. Métis and Inuits have their own colonial legislative relationships with crown relatives, with the crown, and that is relative with the First Nations. So essentially, we are looking at a different legislative relationship altogether, because the relationship that the crown has with indigenous peoples is governed by the Indian Act. Okay. And therefore, whenever we are talking about a contract with any First Nation, whether it's Pipikaisis, whether it's Inuits, whether it's Métis, whether it's Mississaugas, whether it's Red Band Council, we are essentially looking at a different kind of a contractual relationship. And therefore, we need to be able to understand how these contractual relationships work. So we first need to check whether the person or the representative of the First Nation with whom you are entering into a contract, does that person have the requisite authority to enter into a contract in the first place? And First Nations in Canada exercise that authority under the Indian Act of 1985, which is essentially Royal Statutes of Canada, 1985. So First Nations in Canada exercise their authority under this act. The courts in Canada have often turned to or read Section 2, subsection 3B of the Indian Act to provide or to go or to look at the relevant factors in determining whether the First Nation was or has or was legally bound to that particular contract or not. So in order to ascertain whether this contract is legally binding with the First Nation, the courts look at Section 2, subsection 3B of the Indian Act. Okay. And what does that section state? It states that a power conferred on the council of a band. So what is a band? A band is essentially the First Nation or a group of indigenous peoples. Each band has a band council. Think of it as you living in a municipality. Municipality has a municipal council. That municipal council has a mayor. Similarly, indigenous peoples have bands. Each band has a band council. So what the section states is that a power conferred on the council of the band shall be deemed not to be exercised unless it is exercised in consent of the majority, with the consent of the majority of the band councillors present at a meeting which has been duly convened. Now, this is a mouthful and sounds complicated, but in fact, it is not complicated. Let's break this down. So far, is it clear to everyone that indigenous groups and peoples organize themselves as bands? Is that clear to everyone? That is a
Yes.
starting point. That is
Yes.
okay. Now, each of these bands will have a band council. That is clear. The way municipality has a municipal council, university has a universal council. It's a council.
I just have a question here. For example, a territory have different aboriginals residing, I mean, Metis or incidents. So will they have a joint board or each identity have their own individual board?
Every identity, it's not called an identity. It's called a band or a First
Okay.
Nation. Each First Nation will have its own band council.
Okay. Thanks.
Okay.
Once
Now-
they nominated by the band, then do they automatically just have the power to just make the decisions like that, or
Yes, they are
each
called
meeting?
band counselors. They are elected by the band. They are usually people, who are elders in the band. They are elected as band councils, just the way you would elect municipal councils, correct?
Mhm.
It's similar to that. So you will have a band council. People who are nominated to the band council are called councillors. And what this act says is that we will, or the courts say that it will be seen as a decision of a band councillor, provided majority of councillors have voted for that particular decision at a duly convened meeting, which means once this council sits, once this council meets, whatever the majority decides will be seen as the decision of that band council. Is that clear? And that decision is going to be binding. Is it
So
clear?
if the band decide to make a contract with a certain company or even government, then
Yeah.
the decision will be made by not by a certain person, then rather
The band council,
made in
councillors. The band councillors are going to make the decision. Is it clear?
Okay, that's clear. Thank you.
Any questions? Anybody? Sonia, Shubham, Olu Watson, Rashmi, Raman, Adiola, Aarti,
Nothing yet.
No,
No, ma'am.
No, ma'am. Yeah, we are clear.
Okay.
Wow.
Suwasti, Khushwant, Nikhil, Sanjay, Mohammed, Fawzia. Any questions? Okay. So this is what section 2, subsection 3b states it has to be by the consent of majority of councillors present at a meeting that is of the council duly convened. So it cannot be like at a dinner party, the band councillors are meeting and then they finalize a contract. No, it has to be a meeting of the council which is duly convened. That means the council should get together in a council meeting and then decide. It cannot be that, oh, all councillors were walking in the park, taking a walk in the park in the evening and they arrived at that decision. No, it has to be majority of councillors at a meeting of the council that is duly convened. That means all the requirements of calling a valid meeting must be met. What are those? You don't have to get into that. You just have to get into understand what is a valid contract that is coming out of this section. Band council must meet at a meeting. This meeting needs to be duly convened and the consent of the councillors have to be taken in majority. Okay. Let's look at the powers of band council. A band council has several powers conferred to it by the federal government through the Indian Act, including the powers to make laws, enforce bylaws for the band, construct infrastructure, impose taxes, give licenses. So pretty much a band council has all the powers that are, that are required in order to govern or run a First Nation. Okay. And all the decisions that come out of band council have to be in form of a band council resolution. And this has to be a written decision, which means all the decisions that come out of a band council, these must be written band council resolutions for them to be legally valid in a way that they bind the First Nation. So if I am looking at whether the contract is valid or not, I would look at multiple factors. Was the contract entered into, or was the contract approved at a band council meeting? Was this meeting duly convened? Did the consent come because, did the majority of councillors vote for it? Was this meeting recorded? Did a written band council resolution come out of it? All these factors I will have to take into account if I have to see that whether a contract with a band council was valid or not. It is not like your common law contract, which requires offer, acceptance, consideration. These are your common law contracts. This is a contract that you enter into specifically with the indigenous groups, with the First Nations. Is it clear to everyone? Any questions so far?
No questions on it.
Okay. Now, what is a band council record? Like I said, in determining whether the factors under section 2, subsection 3b of the Indian Council of the Indian Act have been met, it is a matter of judicial interpretation. So the judiciary will decide if these factors have been met or not. It is not a question of fact. It is a question of judicial interpretation. And, if you have a band council resolution, it's easier for judiciary to decide whether the contract existed or not. Because a band council resolution is a written evidence of the oral decision. Let's say orally, everybody said yes to the contract. But the minute it was put into writing, 5 members backed out. So now there is a discrepancy between oral decision and written decision. Therefore, a band council record is required to capture the oral decision. It is an evidence of the oral decision. So tomorrow, let's say there is a fact pattern and you have to understand, or you have to give this answer whether a particular contract exists or not with an indigenous peoples, what is the first document that you're going to look at?
Bar Council, Band Council. Sorry.
Band Council resolution. You will just tell me, Hannah, we will look at the Band Council resolution to see if this contract is valid or not. However, we also need to check, Hannah, that the existence of a Band Council resolution or the existence of a valid contract depends squarely on judicial interpretation. But if we have a written Band Council resolution, then why do we even need to go to the judiciary? It is clearly mentioned that you have that contract. So the first thing, as students of law, the first thing that you will look at is, what is the first document you look at?
Band Council resolution.
And council.
Band Council record, Band Council resolution. Please remember this and never forget. Any questions, anyone? Cynthia, Shubham, Oluwatsin, Rashmi, Raman, Adiola, Aarti?
No, ma'am.
No, ma'am.
Is
No,
everyone
thank you.
with me till here? Essie, Swasti, Kushwant, Nikhil, Fauzia, Mohammed, Sanjay, are you with me till here?
Yes, ma'am.
Sanjay? Sanjay, are you with me?
Yes,
Which document are you going to look at if you have to establish whether
Band Council.
Band Council what? Which document you will look at?
Resolution.
Band Council resolution or
Resolution.
Band Council record. Okay, what is a Band Council? What is a Band Council?
Majority of the band representatives.
Band Council is the representative body of the First Nation. You have municipal councils, right? What are municipal councils? What
They
are
are representatives of the municipal council.
representative of the municipality? Correct?
Yeah.
Similarly, you also have representatives of a band. They are elected to a band council. And how are decisions taken in that band council?
The majority of people which they accept.
Majority of councillors. Yes,
Yes.
that is right. So is the process now clear to everyone? Any-
Yes.
Yes.
Okay. Now let's look at the first case law, which is Heron Seismic Services Limited versus PP Kaises Indian Band. Now, in 1984, there were contractors called Heron Seismic Services and Montes Drilling Limited. So this is a contractor, and they drilled and developed 38 deep water wells on PP Kaises Indian Reserve. So there was an Indian reserve, and wells had to be dug so that people could access drinking water. So this job was performed by Heron Seismic Services and Montes Drilling Limited. The total cost of digging these 38 wells was $374,000. Okay. The members of the PP Kaises Indian Band, they were under the impression that this cost would be met by the government, that the government is going to pay Heron Seismic Services for digging wells on their land. The government schemes only paid $100,000. The contractors, Heron Seismic Services, they sued the band council. They sued the band. They sued PP Kaises Indian Band for the balance amount. The contractors claimed that Indians of this band, that PP Kaises Indian Band, they knew that they would be liable for any balance that, had to be paid after the government grant. So their argument was that these people knew that they had to pay for the balance amount. They were, you know, they knew that government grants would only pay a part of the cost. The rest of the cost will have to be met by them. The contractors, they submitted that they had verbal contracts that existed between themselves and the Indian band and the individuals that were occupying the land. The band claimed that there was no contract, verbal or otherwise, because there is no agreement. Where is the agreement? You can't have a verbal contract for $274,000. Where is the agreement? Furthermore, even if there was a contract, the requirements under Section 2, subsection 3B of the Indian Act were not met. And there was no band council resolution. And the contracts in this case, they said these contracts also required minister's approval. Back in the day, some of these contracts required minister's approval. Where is the evidence of this contract? The Saskatchewan Court of Queen's Bench dismissed the contractor's claim. It said, sorry, the requirements of Section 2, subsection 3B of the Indian Act are not met. If they are not met, there is no contract. So Heron Seismic Services Limited versus PP Kaises is a classic example of how you need to meet the requirements of the Indian Act if you want to look at the validity of a contract. If you see your website, I have explained this in detail. The Indian Act Section 3, what power, that is the rule. The application was whether the contract is valid or not. And finally, it dismissed the contractor's action, and therefore the Indian band cannot be held liable for work done on its reserve without authorization via band council record. I have organized this in form of IRAGs. So the issue was, can an Indian band be liable without authorization via band council record? That's the issue. That's the issue you will be searching for even in your fact patterns. Any questions, anybody? Can you give me a couple of minutes? I'll just stop the recording. Just give me a couple of minutes, please. There's somebody at the door. So let's look at next case law that we have, which is Telecom Leasing Canada versus Enoch Indian Band of Stony Plains Reserves, number 135. In this case, the plaintiff, which is Telecom Leasing Canada Limited, is suing the defendant, Enoch Indian Band of Stony Plain Indian Reserve, for payment under a contract of guarantee. Now, how does guarantee work? Let's say a financial institution, let's say CIBC, gives loan to Fauziya of $100. CIBC says, Fauziya, who's going to pay in case you default? Who's your guarantor? Fauziya goes to Rashmi and says, Rashmi, can you stand as a guarantor for me? Rashmi agrees to stand as a guarantor for Fauziya. And now Rashmi has essentially entered into a contract of guarantee with the bank, stating that in case Fauziya defaults, I will pay. So is that clear? Like, how does a contract of guarantee operate? Is that clear to everyone?
Yes,
Yes.
Right?
it's a pure contract, yeah.
It's a pure contract. So essentially, somebody else is going to pay if you default. That is contract of guarantee. Now what happens is, in this case, Enoch Construction and Services Limited, a corporation, is owned and operated by a band. So there is a band council, there is a band, okay? So the band is called Enoch Indian Band. The name of the band is Enoch Indian Band. And this band has a corporation of its own. Okay, the way a band has a council, this band decides to also float a corporation of its own. This corporation, this company that the band has, it is owned and operated by the band. And this corporation enters into a contract with the plaintiff. Who's the plaintiff here? Telecom Leasing Canada. Always remember, in contracts, we need to know who's doing what. So Enoch Indian Band is the defendant. Plaintiff is Telecom Leasing Canada. Enoch Indian Band has a corporation. This corporation has entered into a contract with Telecom Leasing Canada. This contract is for road construction equipment. So Telecom Leasing Canada is essentially leasing out equipment to this corporation. The plaintiff agreed to purchase the equipment and lease it to the band-owned company. So the plaintiff says that we will purchase the equipment for you and we will lease it to you. You want this equipment on lease? We will give this equipment on lease. But here is the condition. A guarantee, a contract of guarantee will have to be given by the band. Because how will we know that the corporation will return the money to us? Okay, so we need a guarantee from the band. Unless the band will not give us the guarantee, we are not going to give you the equipment. So the band extends commercial guarantee or gives or enters into a contract of guarantee with Telecom Leasing Canada, stating that in case this company does not pay, we will pay you. So far, is the story clear to everyone?
Yes.
Yes, ma'am.
Okay.
Yes.
Now the question that arises is, does a band have the power to enter into a commercial contractual agreement in its own name? Can it give guarantee? The answer is yes. The band council has the power to give guarantee on behalf of the band, and this guarantee is a valid contract and it will be enforceable against Enoch Indian Band. So Enoch Indian Band cannot say, oh, we are a band under the Indian Reserve and we cannot give commercial guarantee. Court says, why? Why can't you give commercial guarantees exactly? You can totally give commercial guarantee. It's a valid contract of guarantee that you entered into. What do you mean by a band cannot give a commercial guarantee? And therefore, in this case, it was stated, clarified, and reiterated that a band can give contractual commercial guarantee, and that will be valid and enforceable against the band. If I share, let me share the summary that I've prepared for you. It's given over here. So the issue was, does the Indian band have the power to stand as a guarantor in a contract? And these were the rules. A duly convened band meeting was held. All the documents were formally presented. Although the Department of Indian Affairs did not give its approval, this guarantee was signed by the chief and the councillor, and therefore they simply said Indian bands have the power to give guarantee and enter into contracts of guarantee. And I have quoted from the case law that I find that the contract of guarantee is enforceable against Enoch Indian Band, and that pursuant to this guarantee, the band is liable for the performance and obligations of Enoch Construction and Services Limited under the lease. So this is how I have arranged the entire case law for you in an IRAC format so that the issue in the exam, you're just able to lift this issue, apply these rules, and move on. Is it clear to everyone? Any questions? Anybody?
No questions.
Okay. let's look at the next case law, which is All Fab Building Components Inc. versus Montreal Lake number 354. Now, All Fab Building Components Inc. is a successor company to New Fab Building Products. So there was a company called New Fab Building Products. It was acquired by another company called All Fab Building Product Components. Okay. So the plaintiffs in this case are New Fab or All Fab, whatever you want to call it. Now, Montreal Lake number 354 is the Indian band here in question, which is also known as Montreal Lake Creek Nation, and it is defined in the Indian Act as a band. Now, it's a largish reserve that is, it's an Indian reserve in Montreal. And the idea in this case was that this band, Montreal Lake number 354, had entered into a contract with New Fab Building Products, okay, to supply certain building materials. So think of it as this Indian man entering into New Fab Building Products. New Fab had to supply building materials to Montreal Lake number 354, which is the Indian band. Please note, after some time, this company was acquired by another company, All Fab Building Components Inc. Okay. The question was, can All Fab Building Components Inc. Acquire, or the contract that Montreal Lake entered into with New Fab, can it be enforced still? Is the contract still enforceable if New Fab no longer exists? Because the band said that, this company, All Fab, cannot produce any documents which indicates that we had any transactions with them. The court said, sorry. Technically, you entered into a valid contract with New Fab. Okay, all the assets, all the accounts receivable, all the contracts were taken over by another company. So you cannot say that we did not have any contracts with another company. New Fab is All Fab, or All Fab is New Fab. It's the same company. Tomorrow, if I change my name from Henna to iPhone, will I stop teaching you contracts? No. The contract stays. So the courts categorically stated that you cannot say that, we never entered into a contract with All Fab. We entered into a contract with the previous company. The previous company no longer exists. The previous company was acquired by this new company, and therefore all the contracts of the previous companies with the previous company, all the accounts receivable that the previous company had to obtain or had to procure, they are all transferred to this one. So you cannot say that we are not going to fulfill our obligations because New Fab doesn't exist. Is this clear to everyone?
Yes.
It's a very simple case. So you entered into a valid contract with New Fab. That contract was signed by the band counselors at a duly convened band council meeting. You had to supply the materials. It was a valid contract. That company was acquired. Does it mean you have no obligation to pay? Think again. And therefore, it said that you may not have an agreement with the successor company. The band council may not have agreement with the successor company. But if it had an agreement with the predecessor company, it is still a valid agreement, provided it was validly entered into. Any questions? Any doubts?
No, ma'am.
Ma'am, I just have one doubt here. Like in this particular scenario, the acquired company has not informed the band group that they are going to acquire this company, and hence this relationship will be established.
Yeah, but then why will they be required to inform the band?
I mean, because there will be a change in the contractual status of the contracting entity. Maybe, I mean, not sure as per the agreement, they might be required to notify if there any change in the uh, acquisition of the company. I mean,
Yeah, so they must have informed the band about the change in ownership. And that's why the band is saying, we don't owe anything to you.
okay.
But the court said, what do you mean?
Got it.
What do you mean by that? Tomorrow, if I change my name from Henna to some other name, will you people forget that you're my students and you paid the amount? No. They'd be like, we
Right.
don't care what you call yourself. You still
Yeah.
have to fulfill the contractual obligation. It's the same thing.
Right.
So
Maybe a trick followed by the band that they don't want to own the payment. That's why they come up with this excuse.
I don't know. We'll have to check with the band. Let's call them up. But this is what happened. Again, this case has been, once you go back to the website and the case laws are uploaded, you will be able to identify that I have done all these cases, detailed summary, and IRAC has been prepared for every single case. The next case law that you have is Jenkins Meat Market and Locker Plant Limited versus Red Sucker Land Lake Band. And with this case, I will end today's session. The facts in this case are very simple. The plaintiff, through its principal officer and shareholder, John Jenkins, visited Red Sucker Lake and sold meat and grocery products to Red Sucker Lake First Nation Band. There was no dispute that the plaintiff, that is Jenkinson, sold meat products worth $38,000 and grocery products to $27,000 to individual band members. So he said he sold some products to the band and then to individual band members. The payments were received only in the amount of $7,000, and there was a balance outstanding principal of $66,000. It was the defendant's position that there was no band council resolution that was passed. And because there was no band council resolution that was passed, there was no contract that was entered into, and the defendants were not liable to pay. The court said, why are you buying the products then? So I told you, it's a matter of judicial interpretation. The court said that if you are purchasing the goods, it means that there was an agreement to purchase the goods in the first place amongst the band members. So you cannot say, oh, no band council resolution, so no payment. You purchased the amount. You still have to pay $66,000. You cannot say, no band council resolution, so no contract. In this case, they said the evidence is very clear. Individual band members were purchasing from Jenkinson's Meat Market. Band had purchased from there, and there was no objection. So just because of a technicality, you cannot throw a valid contract outside the window. And therefore, in this case, it was held that just because the band council resolution does not exist, does not mean that the contract does not exist. And therefore, in this case, they said that they will be responsible for paying the amount, the balance amount. Once again, I can show you how I have prepared these summaries so that you're able to easily access them. This is regarding all fab and new fab. And finally, this is Jenkinson Meat Market. He'd only received partial payments, and he was suing the band to collect the entire amount. In this case, the evidence indicated that the individuals were purchasing for the whole band, and therefore there were partial payments that were being made, and hence this was held to be a valid contract. Okay. And with this, let me stop sharing my screen. With this, we come to the end of our session. If you have any feedback, anything that you want to discuss with me, I am happy to answer your questions. Otherwise, from my side, the class is over. Nothing that I have discussed in this class constitutes legal advice. It does not give rise to any solicitor-client relation or contractual, professional, or fiduciary relation between us. It is only and only meant for educational purposes and to facilitate the understanding of your concepts that are tested by the NCA on their contracts exam. And you were strictly prohibited from recording the sessions, and you are strictly prohibited from using the materials in any unauthorized fashion. In the event I come to know of it that you have, you shall be pursued to the fullest extent of the law. With this, my session comes to an end. If you have no further questions, you may leave the class. Tomorrow, I'm going to meet only the regular candidates at 12:30, and we are going to look at the next topic, offer and acceptance. We are meeting tomorrow once again at 12:30 at 12:30 p.m. Toronto time, Eastern time, and we will discuss offer and acceptance, essentials of a valid contract under the common law. And with that, let me now stop recording the session.
Ma'am, just want to understand.